and welcome back to our channel. My name is Ayush Kumar Singh. I am a legal intern in LEXIS and Company. So today we are going to discuss limitation under criminal procedure. So testimony of witness become weaker with the lapse of time and memory, and consequently the chance of error in judgment increases since the evidence become weaker, putting pressure on the system of criminal prosecution to ensure that the offender is convicted and punished quickly to ensure speedy justice in consonance with the concept of fairness of trial as assigned in Article 21 of the Constitution of India. So, Section 467 of CRPC defines the phase period of limitation. It means the period specific in Section 468 to take cognizance of certain offences. Section 468 stipulates the bar of limitation. Subsection 1 of section 468 make it clear that fetter is putting on the court's power to take cognizance of an offence of the category mentioned in subsection 2 after the expiry of the period of subsection 2 lays down the period of limitation of certain offences. Section 469 states when the period of limitation commences. It is dexterously drafted so as to prevent advantage of a bar of limitation being taken by the accused. It states that the period of limitation in relation to an offence shall be commenced either from the date of offence or from the date when the offence is detected. Section 470 provides the exclusion of time in certain cases. It inter alia states that while computing the period of limitation in relation to an offence, time taken during which the case was being delicately prosecuted in another court or in appeal or in revision against the offender should be excluded. The explanation of this section states that in computing limitation, the time required for obtaining the consent or sanction of the government or any other authority should be excluded. Similarly, the time during which the accused is absconded or absent from India shall also be excluded. Section 471 provides the exclusion of date on which the court is closed, and Section 472 provides the continuing offence. Section 473 is an overriding provision which enables court to condemn delay where such delay has been properly explained or where the interest of justice demand extension or period of limitation. According to Section 468, if an offence is punishable with fine only, the period of limitation shall be 6 months, and if the offence is punishable with imprisonment for term that does not exceed 1 year, the period of limitation is 1 year. Section 468 further make it clear that if the offence is punishable with imprisonment for term exceeding 1 year but does not exceeding 3 years, the period of limitation shall be 3 years. It does not lay down the period of limitation for offences punishable with imprisonment exceeding 3 years, meaning thereby there is no outer limit queued that the limitation in relation to the offences having punishment of 3 years or more. Thus, Section 473 of the Code of Criminal Procedure enables the court to take cognizance of an offence after the expiry of the period of limitation, if it is satisfied on the facts and in the circumstances of the case that the delay has been properly explained. So, in the case of Assistant Commissioner Collector Bombay versus L.R. Merwani, AIR 1970, the Supreme Court held that the question of delay in filing a complaint may be a circumstances to be taken into consideration in arriving at the final verdict, but but itself it afford no ground for dismissal of the complaint. So, moving to the next case, that is Bhagirath Kanodia and others versus State of MP, AIR 1984. The principal question in the decision was regarding continuance of offence spoken about in section 472, but the Supreme Court also drawn points attending attention on of the code to the provisions of section 473 of the code. The question whether a particular offense is continued offense shall necessarily depend upon the language of the statute which creates that offense, the nature of the offense, and above all the purpose which is intended to achieved by the continuing the particular act as an offense. In the judgment, it was held that Section 473 of the Code enact an overriding provision and courts conferred with provisions laying down a rule of limitation governing prosecution will give due weight and consideration to provisions of Section 473 and take cognizance even after expiry of the limitation if interested of justice so required. So I hope you find the video informative, so please like, share and subscribe.